Hi,
Yeah.
everyone. I'm Melissa Rogers. I'm Distinguished Scholar in Faith Law and Public Policy at Wake Forest University Divinity School. Welcome to our webinar on the United States Supreme Court Jurisprudence on Religious Freedom. I'm glad Dean Corey Walker could join us today and offer opening remarks. So, Dean Walker, thank you for being here, and over to you.
Thank you so much, Melissa, and thank everyone for joining us today. Reflecting on the crises of the 20th century, noted political philosopher Hannah Arendt spoke of dark times, when light does not altogether disappear. Rather, the moment is characterized by truth that is hidden, speech that is distorted, and the diminished capacity of humans to see one another clearly. In such moments, the principles and practices that bind communities begin to erode. The circle of we narrows, and solidarity becomes increasingly fragile. The challenge of dark times is magnified during periods of deep political tension, when disagreements over policy, principle, or procedure take on the weight of existential conflict. In such moments, our political imagination falters, leaving us bereft of the shared language necessary to affirm our membership in a common political community or to sustain solidarity across difference. Distinguished scholar of law and religion John Whitty Jr. reminds us that even periods marked by profound conflict have produced affirmations of deep human dignity. We need only look to the turmoil of the 1960s, a decade that also produced the Civil Rights Act of 1964, the Voting Rights Act of 1965, the Conciliar Declarations of the Second Vatican Council, the International Covenants on Civil and Political Rights and on Economic, Social, and Cultural Rights. And to be sure, these documents owe part of their existence to the right of religious freedom, which has long been a foundational part of the gradual development of human rights and is regarded as a cornerstone in the edifice of human rights. Religious freedom has long stood among those foundational rights that make democratic life possible. It is this critical perspective that has shaped my own scholarship on religious freedom and that informs today's conversation. Across legal, public, and scholarly debates, religious freedom can illuminate both our foundation, this foundational liberty, and our contemporary democratic life. In dark times, this work becomes vitally important. At stake is nothing less than how Americans understand the constitutional foundations of democratic life across profound differences of belief and conviction. Religious freedom in dark times must cut through dogmatic rhetoric, for what is at stake is nothing less than democracy in America. This is not a hyperbolic statement. As we commemorate the 250th anniversary of America's founding, we are reminded that the promise of constitutional democracy has expanded only gradually and often through bitter struggle. And America has only been a functioning multiracial democracy for little over half a century. And while there has been tremendous progress, our democratic journey is far from complete. This is what makes today's conversation reviewing the Supreme Court's recent religious freedom jurisprudence so important. Because constitutional law has become one of the principal languages through which Americans negotiate questions of freedom, equality, dignity, and authority. The Supreme Court's religious freedom decisions carry implications well beyond the litigants. They shape public life, they shape public institutions, civic life, and citizenship, identity, and belonging. A final thought. Paul Tillich's evocative statement, the boundary is the best place for acquiring knowledge, encapsulates the essence of what must be done in our current conjuncture. For Tillich, the boundary represents a space of engagement where knowledge is both acquired and challenged. In the context of contemporary American law, religion, and politics, the boundary is not just a metaphor. It is a space for each of us to find fresh expressions of freedom. Thus, it is my hope that today's conversation will inhabit that boundary where convictions are tested, assumptions are challenged, and new possibilities for freedom and deep democracy may emerge. I know this will be a wonderful program, and I look forward to the conversation.
Thanks so much, Dean Walker, and thanks for your leadership at Wake Forest. We're so glad you're here and grateful for your support. And we're fortunate to have a terrific panel of constitutional scholars with us here today for today's conversation. They are Stephanie Barkley, Professor of Law at Georgetown University School of Law and Faculty Co-Director of the Georgetown Center for the Constitution, Tom Berg, the James L. Oberstar Professor of Law and Public Policy at St. Thomas School of Law in Minnesota, Alan Brownstein, Distinguished Professor of Law Emeritus at the University of California at Davis, and Audra Savage, Associate Professor of Law at our own Wake Forest University School of Law. And there's more information about each panelist at the links and the invitation, so I hope you'll check it out. Now, to set the stage for our panelists' opening remarks, I'll give a basic and very brief sketch of some cases we'll discuss today, starting with Landor versus Louisiana Department of Corrections. This case involves a claim by a Rastafarian inmate, Damon Landor, whose faith requires him to leave his hair uncut. Nonetheless, state prison guards, however, forcibly shaved Landor's head. Landor then sued for damages under the Federal Religious Land Use and Institutionalized Persons Act, otherwise known as RLUIPA. The claim at issue was made against individual prison officers in their personal capacities. By a vote of 6-3, the Supreme Court held, however, that under a spending clause statute such as RLUIPA, Landor's claim couldn't proceed because these correctional officers hadn't voluntarily and knowingly consented to face such liability. Now, the Landor case was part of what's called the court's merits docket, the relatively small number of cases the Supreme Court hears each term that are subject to multiple rounds of briefing, oral argument, a private meeting of the justices, and lengthy written opinions. But there's another lesser-known docket, variously called the shadow or interim or emergency docket, where the court makes rulings without that kind of process, including by denying or granting quote-unquote emergency relief, such as freezing a lower court ruling or a government policy that lower courts refuse to block. The Supreme Court's ruling in our next case, Mirabelli versus Bonta, was part of this lesser-known document. And this case includes some claims by parents that California policies violate their constitutional rights to guide the development of their children. Among other things, these parents say that these policies prohibit public schools from disclosing a student's gender nonconformity at school to others, including to students' parents, if a student doesn't consent to sharing such information with them. And thereby, the parents say their rights have been violated by the state, specifically the school. A trial court certified a class action lawsuit by plaintiffs and granted an injunction prohibiting state employees from misleading parents about their children's gender presentation at school, for example. But an appellate court stayed that injunction for a variety of reasons while the state's appeal of the lower court decision proceeded. And at that point, the parents sought emergency relief from the United States Supreme Court. A court majority gave these parents a win, reinstating the injunction during the appeal. In a dissent, however, Justice Kagan said the majority's decision was an illustration of how, quote, the emergency docket can malfunction, unquote. Now, let me quickly mention two cases the court has agreed to hear next term. The first is St. Mary's Catholic Parish versus Roy. This case involves a Colorado universal pre-K program in which both private and public, and when I say private, I mean including religious schools, may participate. The program prohibits discrimination on bases such as race, ethnicity, religious affiliation, sexual orientation, and gender identity, as these characteristics apply to the child or the child's family. Some faith-based preschools that would like to participate in the program say that, for religious reasons, they cannot fully comply with the non-discrimination conditions on religious affiliation, sexual orientation, and gender identity. These preschools sued the state, claiming enforcement of the non-discrimination provision against them is invalid under the First Amendment, and it would be invalid as to the specific grounds of non-discrimination that I mentioned earlier. In April, the Supreme Court agreed to hear this case in its upcoming term. It also agreed just recently to hear a case called Grand versus City of University Heights. Daniel Grand is an Orthodox Jew whose faith forbids driving on the Sabbath, and it requires him to pray frequently in a group of 10 men. He invited some neighbors to join him for prayer in his home. After some other neighbors complained, the city sent Grand a cease and desist letter telling him he needed to apply for a special use permit in order to use his home as a place of religious assembly. Grand initially applied for such a permit, but subsequently withdrew his application, saying he didn't wish to operate a house of worship at his home, so that special use permit was irrelevant. He just wanted to host his prayer gatherings there. He later filed First Amendment and RLUIPA claims. Here, RLUIPA claims involving the land use provisions of that law, as opposed to the institutionalized corrections and other facilities provisions of RLUIPA. In the Grand case, lower courts have said that Grand's claims aren't right because the city never made a final decision regarding a special use permit. But Grand says once the city told him to stop hosting prayer gatherings at his home, his free exercise rights were violated and must be vindicated now. And last but certainly not least, we'll discuss cases challenging state laws requiring the posting of 10 Commandments in public school classrooms. Now, to be clear, the Supreme Court hasn't agreed to hear any of these cases yet, but it may well do so in the future. In 1980, a United States Supreme Court majority struck down a Kentucky law requiring the posting of a copy of the 10 Commandments on the wall of each public school classroom in the state, saying that the law had no secular purpose and was thus unconstitutional. But lately, several states, including Arkansas, Texas, and Louisiana, have passed similar laws, and courts have begun to rule on the challenges to those laws. Most notably, in April of this year, a closely divided Fifth Circuit Court of Appeals narrowly upheld the Texas law, emphasizing recent changes in Supreme Court doctrine. Well, now we'll turn to brief opening remarks by the panelists. Alan, can you get us started?
Thank you, Melissa. It's a privilege to be on this panel with so many distinguished scholars. Most of my preliminary remarks on today's panel focus on the court's truncated and diminished interpretation of the Establishment Clause. I hope to discuss free exercise issues during Q&A. My understanding of the Establishment Clause is grounded on several core principles and values. I'm not sure that the current court supports any of them. Indeed, I'm not sure that the court recognizes that there are any principles or values relevant to its interpretation of the Establishment Clause. Instead, the court may rely exclusively on its understanding of what the alleged hallmarks of an establishment of religion were understood to be in 1789, without regard to the principles on which those hallmarks were based. So, what are the principles that I think should be the foundation of Establishment Clause jurisprudence? Primary principles. Religion should be voluntary and left to the individual's determination. The government should have no control or influence over matters of faith. Further, we don't trust government on matters relating to religion and are rightly concerned that the majority will not respect the rights and interests of religious minorities. Derivative principles. We don't determine religious truth through legislative deliberation, executive fiat, or the ballot box. The government can't coerce religious conformity through penalties or the denial of benefits. The current court might actually accept this if it is ever willing to find that coercion exists. It's impermissibly coercive for government officials who enjoy discretionary authority to provide important benefits to or impose significant sanctions on individuals, to invite those individuals to join the government in prayer or other religious activities. To paraphrase The Godfather, often these invitations are offers the invitee can't refuse. The risk of doing so is too high. Also, it should be impermissible for government to use its power and resources and voice to promote religious conformity, even if it is not directly coercive in doing so. The Supreme Court stated this explicitly in the school prayer cases. A second set of core principles recognizes that the way the Constitution relates to religion is multidimensional. It extends not only to religious liberty, it also encompasses religious equality and freedom of speech. The Supreme Court recognized the primacy of a constitutional commitment to religious equality in Larson versus Valente in 1982. But this religious equality, anti-preferentialism conclusion can't be grounded exclusively on history. Religious equality was honored in the breach in 1791. Anti-Catholicism was rampant. Native American faiths and African religions received no respect whatsoever. With the adoption of the 14th Amendment and the Equal Protection Clause, however, the constitutional commitment to equality radically changed. Now, racial minorities, women, groups defined by national ancestry, non-marital children, and gays and lesbians have claims to equal treatment. It's hard to understand why religious minorities should not be similarly entitled to equality. I would argue that the Establishment Clause jurisprudence, until recently, was heavily influenced by the constitutional commitment to religious equality, although that commitment was implemented through Establishment Clause doctrine, not through the Equal Protection Clause. The court seemed to recognize that under our Constitution, adherents of different faiths and non-religious individuals are of equal worth and must be treated by their government with equal respect. Finally, free speech doctrine complicates religion clause jurisprudence. Free speech doctrine prohibits the government from distorting the marketplace of ideas through viewpoint discrimination. And the court has held repeatedly that religion is a viewpoint of speech. But much of religious practice and exercise is speech. Prayers, sermons, proselytizing, the publication of scripture, religious teaching in religious schools, religious assemblies and houses of worship are all both religious exercise and speech. Thus, we have this constitutional conundrum. Accommodating religious exercise by treating it differently than secular activities seems acceptable, if not required, by the Free Exercise Clause. But treating religious expressive institutions and activities more favorably than their secular counterpart seems to violate the prohibition against viewpoint discrimination mandated by free speech doctrine. So how can we protect religious exercise without simultaneously distorting the marketplace of ideas by privileging religious expression? I don't think we can sensibly limit free exercise protection and accommodations to only non-expressive religious practices. An alternative approach is to recognize that the limits the Establishment Clause places on government religious speech can temper the distortion of the marketplace of ideas created by the privileging of private religious expressive activities. Establishment Clause constraints on government religious speech offset that privileging of religious messages and ideas. The two clauses operating together create a form of rough neutrality, favoring private religious messages through free exercise mandates and statutes, while limiting religious messages expressed or promoted by government. If we take religious coercion, religious equality, and free speech principles into account, the Establishment Clause should be interpreted to impose serious constraints on government religious speech or the promotion of religious beliefs. The Texas Ten Commandments case, which Melissa summarized, should be an easy case. The Texas statute mandating the display of the Ten Commandments in public schools should be struck down as unconstitutional. The law is clearly preferential and favors certain faiths over others. It uses the power and resources of the state to promote religious conformity. The permanent and obtrusively distinctive display of the Ten Commandments in every public school classroom is an obvious effort to proselytize on behalf of particular religions, just as a large Latin cross on the roof of City Hall would constitute impermissible proselytizing by government. And the language of the display is overtly proselytizing. I am the Lord thy God. Thou shalt have no other gods before me. Remember the Sabbath day to keep it holy. Now, this doesn't mean that all government religious speech is unconstitutional. Religion clause jurisprudence of necessity is going to be nuanced and complicated. I'm out of time, but I'd be happy to elaborate on this point in Q&A. But a court that cares about religious liberty, religious equality, and freedom of speech, and which recognizes how pervasive religion and speech are in our society, that court needs to set its ideological convictions aside and do the hard work of developing doctrine that recognizes and respects the importance of religion and speech, and recognizes and respects our commitment to liberty, equality, and pluralism, and that recognizes the unavoidable conflicting interests that must be taken into account in resolving church-state disputes in our complex society. Thank you.
Thank you so much, Alan. And next we'll hear from Audra Savage. Audra, go right ahead.
Great. Thank you, Melissa, and thank you for inviting me to be part of this most auspicious occasion with these wonderful scholars. For the past 20 years, the Roberts Court has taken up one, if not two, religious liberty cases in each term. Reviewing each case on its own, you may think the court's reasoning is valid, and the decision for a particular case is a logical evolution of First Amendment doctrine. Taken together, however, these cases demonstrate a concerning trend by the court. I'm a big picture scholar. I'm more interested in looking at trends, directions, and misdirections of the court and putting them in social, political, and historical context. When I do this, I cannot help but conclude that the court is using religious liberty doctrine to further retrench from the civil rights gains of the past 50 years, those gains that Dean Walker spoke of. And they're doing this, and they're reducing the gains that brought racial minorities, gendered minorities, and members of the LGBTQ plus community more fully into the political and social community of America. Further, they're entrenching a particular vision of America that's been promoted by the evangelical right, a country that is Christian, heterosexual, lots of babies, and is white. How have they done that? We'll be discussing the most recent cases in a few minutes, but let's take a look at the past few years in the religious liberty area. The court has ruled that anti-discrimination laws are not generally applicable if they allow any exemptions. They have created the so-called most favored nation doctrine, whereby religious persons and institutions must be treated as favorably as secular persons and institutions. The court has ruled that taxpayer money must be used to support religious schools, as in providing tuition assistance to parents or in resurfacing the playground of the schools. And don't forget that the large majority of religious schools in America are Christian-based. Employers now have the burden to prove that allowing a religious accommodation is an undue hardship, when the rule used to be that they only had to show a de minimis hardship. And of course, we can never forget that football coaches must be allowed to pray on the 50-yard line immediately after a game. Does anyone for 1 second believe that the case would have turned out the same if the coach had pulled out his prayer rug and offered thanks up to Allah? Or if he arranged statues of Buddha on the 50-yard line, lit incense, and chanted with beads? I don't think so. Finally, in its parade of horrible decisions, we have the Mahmoud case from last year, which now allows parents to opt out of material that exposes their child to same-sex relationships in children's books. The problem is not only the outcome of these decisions taken together, but to me, what's been more damning is the way they have come to these decisions. They have destabilized the law for practitioners and the lower courts by overturning well-settled law and doing so with thin reasoning and specious claims of precedence. They overturn problematic but still useful tests like the Lemon Test with more problematic ambiguous tests like history and tradition that call us back to a racist, sexist, homophobic, and highly problematic past. They cherry-pick facts of the case and base their rulings on those delectable cherries, ignoring other parts of the trial record that don't support the outcome that they want. And most egregious, they use the emergency docket, aptly named the shadow docket, to decide cases, as Melissa mentioned, meaning that they are making consequential decisions without full briefing and without allowing the claimants to have a full hearing. Not only does it deprive the claimants with their rightful day in court, but it also leaves the lower courts with doubt and confusion as they have no clear precedents or guidelines to follow. This problem has become so large that it has reached popular media. I don't know if any of you caught the segment on Last Week Tonight with John Oliver, where he eviscerates the court for 5 minutes on its use of the shadow docket. So what has the court done recently? I want to highlight the decision in the Landor case that Melissa mentioned at the beginning of the hour. I won't repeat some facts, but I do want to call out that while they were shaving, or right before they shaved and forcibly held him down to shave his dreadlocks, Mr. Landor was holding a state court decision allowing him to have those dreadlocks in court, by the court, in prison. The officials threw away that decision as they threw away his dignity. And Mr. Landor only had 3 weeks left in his sentence before he was free. This is one of the most egregious and shocking violations of religious liberty to come before the court. And what did the court do? It interpreted the spending clause to deny remedies to this religious minority whose body and religious practice were violated with the power of the state. The court never addressed the decades of discrimination faced by imprisoned Rastafarian members who are overwhelmingly Black. Nor did the court address the legislative history and congressional meaning of the Religious Land Use and Institutionalized Persons Act, RUPA, to protect the most vulnerable against religious violations. Instead, the majority only provided a sterile clinical interpretation of the spending clause, the underlying basis for RUPA, sidestepping any discussion of the religious liberty violation. And side note, the court got the interpretation of the spending clause wrong, and it has wide-sweeping implications, but more on that later. The court ignoring and not even addressing the religious liberty violation of this racial religious minority adds validity to my concerns about the court's trend of aiding the project of Christian nationalism that has been ongoing for years. Religious liberty only seems to matter to the court if you are a white and conservative Christian or adjacent to conservative Christians. There is real harm if the court keeps going as it has. I'm concerned that the court is ushering in an era where racial discrimination will soon be tolerated if it's in the name of religious liberty. Intolerance against same-sex marriage and persons is already being allowed. I really do think the next step is allowing racial discrimination. The recent birthright citizenship case has only bolstered my fear. There, the court granted certiorari to hear a case that's already been crystal clear. The meaning of the 14th Amendment is plain. Fortunately, they decided the Constitution means what it says. Though it is very troubling that there were 3 justices who dissented in that case and would allow the power of the 14th Amendment, an amendment created to further end slavery, to be eroded by executive power. I have real fear about where the court is heading as they fail to uphold the Constitution and allow the government to remove voices and communities from the political table, which decreases religious liberty and civil rights for all. Now, these are just a few of my musings, and I look forward to discussing the recent cases more fully in a few minutes. Thank you.
Thank you so much, Audra. Okay, Tom, over to you.
Hi, thanks for having me. This is a great group, and I'm looking forward to the discussion. So I'm going to speak about 2 cases that Melissa mentioned that are at the core of each of the provisions of the First Amendment, free exercise and non-establishment. The free exercise case is St. Mary Parish versus Roy. As Melissa said, that involves Colorado's universal preschool program, under which families can receive funds to send their child to one of almost 2,000 participating preschools, public and private, in the state. But families in Denver's Catholic schools are denied funding because those schools, for religious reasons, admit only families that support Catholic teachings, including on sexuality, which excludes same-sex families. The state says that this violates a condition that participating schools must give families equal opportunity without regard to sexual orientation or other features like race, sex, religion, disability, and family income. So if that non-discrimination condition is quote unquote neutral toward religion and generally applicable, it can apply to the Catholic schools. That's the rule of Employment Division versus Smith, the controversial 1990 decision that the court now seems to doubt but hasn't reversed. But the schools say that the state's rule is not generally applicable because the state agency has adopted a system of preferences allowing providers to consider several of the above features in admissions decisions. So providers are allowed to favor disabled children or low-income children and even confine their programs to those children. In addition, there's a so-called catch-all preference that allows providers to favor children from quote-unquote specific communities. And the agency's director testified that this would allow providers to favor applicants who have faced historical discrimination. For example, LGBTQ families or historically underserved children of color. So the state allowed these exceptions from strict formal non-discrimination, but then refused an exception for the Catholic schools to be able to confine themselves to families who follow traditional Catholic sexual norms. The court is very likely to hold that these rules are impermissibly selective. It has enforced, the court has enforced the general applicability requirements stringently. It says that a law flunks it if it treats any comparable activity more favorably than religious exercise. If a state values and protects even a few secular interests, it must likewise highly value and protect the constitutional interest in religious exercise. So Colorado lets programs have preferences to meet the distinctive needs, which are unquestioned, of disabled children, low-income children, and others from disadvantaged communities. But traditional Catholic families are comparable. They also have distinctive needs, and religion is also a protective characteristic in that list. Denver's Archdiocese believes that Catholics' distinctive needs require school communities where parents follow distinctive Catholic values, including opposite-sex only marriage. I think on that ground, the court is going to hold this not generally applicable and rule against the states. I filed a brief supporting the Catholic schools. Broad, meaningful protection of free exercise, whether that is through overturning the Smith case or through rigorously enforcing general applicability, is consistent with its constitutional status and also with the best interpretation of history, which I can discuss more in the Q&A. But if protection of free exercise should be meaningful, so should protection against religious establishments. And that's the issue in the Ten Commandments case. The Fifth Circuit upheld the state law requiring their display in every public school classroom. It reasoned that the Supreme Court has recently overruled the Lemon Test, which had disapproved such displays, and has limited the Establishment Clause to cases of coercion to engage in a formal religious exercise like prayer or worship, which merely displaying the commandments doesn't do. Fifth Circuit was wrong about that, I think, and you don't need to resurrect Lemon to say that. The recent SCOTUS decisions emphasizing coercion appeal to history, specifically to the founding era hallmarks that Alan mentioned. Maybe it was Melissa. But in other areas like the Second Amendment, the court says, the majority says, that a historical approach looks not for a historical twin, but rather for analogs as determined by the principles that underpin historical practices. And I'm quoting here from those decisions, the how and the why. That reasonably flexible approach focused on the evils that a provision was meant to prevent should also govern the Establishment Clause. The Fifth Circuit wrongly demanded a twin, not an analog. So first, it's clear that historic establishments included coerced religious instruction, not just coerced religious exercises like prayers or worship. Mandatory church attendance was a core part of establishment, and church included instruction. Mark Storsley and Michael Helfand have shown that English and colonial laws required that people maintain silence during sermons as well as during prayers. Indeed, the English and colonial laws required that the Ten Commandments themselves be displayed in every Anglican church, near the altar, quote, as one of the laws said, where the people may best see and read the same, end quote. Texas's Ten Commandments displays, classroom displays, are coerced instruction like that. Students are coerced to attend public schools daily. The court's majority said so last year, I think correctly, in protecting religious families from secular indoctrination in curriculums. The Ten Commandments are themselves religious directives and instructions. Thou shalt have no other gods before me. The statute says nothing about posting other documents to contextualize the commandments as elements of American history or culture. And the statute requires that they be posted in the instructional setting of the classroom conspicuously and legibly. That's so that they can be seen and read. Historic establishments coerced attendance at church, where people could see and read the commandments for religious instruction. Texas coerces attendance at schools where students do the same. I've supported meaningful free exercise rights for 30 plus years through books, articles, and briefs. The Establishment Clause works with free exercise to prevent government-imposed uniformity in religious matters. If we read history flexibly for free exercise purposes, but very grudgingly for non-establishment purposes, the religion clauses will lose their credibility as a source of protection for everyone. Thanks.
Many thanks, Tom. Really appreciate it. Stephanie, over to you.
Thanks so much for having me. It's a treat to get to be with this group and to be part of this conversation. And thank you, Melissa, for organizing, and Wake Forest for hosting us. Okay, so let me hit on a few overview themes of what I see the Supreme Court doing in the past, in recent terms, and in the upcoming term. And then I want to just respond to a couple points that have been made by my colleagues and friends on this panel. So one organizing theme of the direction which the court is moving for both the Free Exercise Clause and the Establishment Clause is to ground its jurisprudence more clearly in original meaning of both of these clauses at the founding. So the court is looking to history in order to try and better understand what that founding era history tells us about the original public meaning of those clauses. Last term and so for example, there's parallel principles that go hand in hand when we're looking at the Free Exercise Clause and the Establishment Clause historically. At the founding, disestablishment forbade government from coercing participation in different types of religious exercise. But it also forbade government from penalizing or persecuting people for their religious exercise. There are a lot of principles like that that operate with establishment and free exercise as opposite sides of the same coin. And I think the court's decisions in this vein are similar. Last term, Mirabelli, an emergency docket case Melissa mentioned dealing with parental rights, really emphasized the seriousness of Mahmoud and what a broad decision that is, offering religious protection for parents' religious exercise. The Ninth Circuit said that Mahmoud was just a narrow decision, and the Supreme Court made crystal clear that Mahmoud is not a narrow decision, that that's a robust protection for parents' religious exercise when they're objecting to things that government is doing that is interfering with their religious upbringing, that's putting objective pressure on parents' ability to act consistent with religious exercise. That objective pressure might look like forcing parents to choose to withdraw their children from public school, or in Mirabelli, where the school is just hiding information from the parents altogether. That was something that the court found is an even more significant interference with the parents' religious exercise. In the year ahead, I think the centerpiece case to keep an eye on is the case that's been mentioned already, St. Mary's Catholic Parish. One thing I want to mention about that is there's been discussion about this being a case that's pitting LGBTQ rights against religious rights. I think the better way to think about that case is how the court is likely going to rule is to try and put religious rights more on a par with LGBTQ rights. So below at trial, Don Odin, who's the director of Colorado's Universal Preschool Program, testified that permitting schools could exclude any students or children other than gender non-conforming children. They could prioritize children of color or children from other underserved areas. They could grant preference to a child based on the child or family being part of the LGBT community. So Colorado is already allowing schools to provide preferences for vulnerable communities, LGBTQ communities, based on their special needs. I think that's a good thing in our pluralistic society. How the court is likely to rule is that what's good for the goose is good for the gander, and Colorado can't allow those sorts of exceptions to prioritize LGBTQ communities, but then say religious schools can't prioritize members of their own community as well. So I think what you're going to see there most likely is a ruling where the court is going to require more of an even-handed approach to that. Maybe in Q&A we can get into some of the historical reasons also why I think a ruling in favor of St. Mary's is going to be most consistent with the original meaning. Then the other thing that I will touch on briefly is let me go into a little bit more the concern that this court is rolling back protections for religious minorities or other vulnerable communities. I just don't think, with respect, that is accurate. So Mahmoud itself, the case that the court recently decided, I think it's easy to try and pit this stereotype. It's a caricature of Christian religiosity against LGBTQ rights. Some of the lead plaintiffs in Mahmoud were Muslim families who also have traditional beliefs about marriage. And so that was a case that was defending vulnerable religious minorities and their beliefs that aren't always politically popular. Holt versus Hobbs and Tanzan are both cases where we had protection, Holt versus Hobbs unanimously, of a Muslim plaintiff. So the idea that in the Kennedy case, if the plaintiff had been Muslim, it would have turned out differently, I just don't think is borne out by the court's track record there. Fulton, another unanimous case, was a case where the lead plaintiff, Sharon L. Fulton, is a Black woman. And she had talked about how she's experienced a lot of discrimination in her life, but she had never experienced religious discrimination like she had at the hands of Philadelphia, excluding her and the foster agency that she worked with, the Catholic Foster Agency, from foster care because of their religious beliefs. So that was another example of a case that was protecting minority communities. Over 70% of the children served by that Catholic foster agency were Black children in that case. And the city was not letting the agency continue to serve them despite the severe shortage of parents that were needed in Philadelphia at that time. The last thing I'll point out is that the Supreme Court has been and will continue to, I think, in St. Mary, has been chipping away at Employment Division versus Smith. If anything, that was a case that is about, I think, a callous approach to protection for religious minorities. In a recent article that my co-author Matthew Crowder and I wrote in the Panel review, we looked at the Supreme Court papers leading up to the court's decision in Employment Division versus Smith. And there was a lot of discussion on the record about oddball religious minority groups that were cropping up and that the court didn't really understand and didn't want to protect. And they were worried that a robust religious exemption regime would provide unworkable protection for religious minorities. But our experience under regimes like RFRA, I think, proves that the opposite is true, that we need a robust religious regime precisely because it is vulnerable religious minorities that most need that protection and that are most likely to fall through the political process. And then the last thing that I'll say briefly on the Establishment Clause, I'm sure that we'll get into this more, but it's true that history does not always equate to original meaning. The court made clear about that in the Second Amendment context recently in its Wolford case, where it declined to use history of Jim Crow laws disarming Black individuals to interpret the Second Amendment. They found that as counter history, not history indicative of the constitutional commitment. So I think equating history to original meaning isn't something that you can do automatically. But what the court is doing in the Establishment Clause, the Free Exercise Clause, in the Second Amendment context is trying to figure out which history is indicative of the constitutional meaning. And constitutional meaning is also not the same as purposes. There are sort of infinite purposes for why we would pass a law. That's the reason why we passed law to begin with, to have settlement and to coordinate action in a way that we couldn't if we just always relied on abstract purposes. And it's true to Tom's point that the Free Exercise Clause and the Second Amendment have a more flexible approach, but it's also true that the Supreme Court has pointed out that those are defeasible rights where the government can come back and say under strict scrutiny, yes, but we have a really important reason to override the right here. The Establishment Clause is not a defeasible right. It's a categorical prohibition on government action. And the court has generally, in other contexts, interpreted categorical limitations like jury protections, like the Third Amendment right against having troops quartered in our homes. They've interpreted that narrowly because it's such a strong protection. I think that that's right. It doesn't have to be a historical twin. it still isn't a historical twin to say no coerced religious exercise is one of 6 different hallmarks of an establishment. But lower levels of generality are more appropriate when it is a prohibition on government action that is categorical and there's no safety valve under something like strict scrutiny that does exist in the Second Amendment and the free exercise context. And those rights also draw on a natural rights tradition and a broader sort of general law framework that it's not clear existed under the Establishment Clause. Some scholars like Judd Campbell think the Establishment Clause is more just a creature of positive law, and it's another reason why it ought to be interpreted more narrowly. And I'll go ahead and stop there.
Thank you so much, Stephanie. Well, as you can see, we have so much on the table, and I want to just thank our panelists for raising so many interesting issues and also for the diversity of their views and their engagement with one another across both shared views and differences in views. I also want to thank our audience who is submitting questions, and you really got some great questions, and we're going to start to turn to those questions now. So let me start by, first of all, let me say as a blanket invitation to the panelists, if you heard something that you would like to respond to in any segment of the QA portion of the program, feel free to go ahead. However, I will ask a couple questions about our 2 RLUIPA cases in this first segment. The Landor case that involves the institutionalized provisions of the statute and more specifically correctional institutions, and also the Grand case that involves some of the land use provisions of RLUIPA, and also the Grand case involves constitutional claims as well. But starting with Landor, we've heard different views from you all about this, some criticisms of the court's decision. There's a 6-3 decision. In her dissent, Justice Jackson said that the court in the Landor decision ignored decades of precedent affirming congressional authority to use the power of the purse to govern and thereby seriously undermine some of Congress's greatest legislative achievements, including RLUIPA. So wondered if any of you want to sort of dig into that more to say, do you think she's got that right? Or do you think the majority had a sound decision? And then we know already, and by the way, there's so many on this call who work to get RLUIPA passed and or have worked to litigate or support claims made under this statute. So there's a whole bunch of interest in trying to respond to the Supreme Court's decision, either through some kind of legislative or executive branch fix. So I want to throw that out as well. If anybody wants to talk about that conversation and what's emerging as some suggestions, their pros and cons and the like, then that is most welcome. So let me just throw open the floor. When you're ready to respond, panelists, just go ahead and start talking, and then we'll try to get in as much as we can in this segment and then move to some of the other cases.
Yeah, I'll go ahead. Oh, Tom, I don't know if you wanted to, you're going to say something.
Go ahead.
Yeah, Audra and then Tom. Yeah.
Okay. Yeah, Melissa, you posed a question regarding Justice Jackson and whether or not she was right in saying that it's ignoring decades of Congress to affirm the authority of the power of the purse. And I agree with Justice Jackson. I think that's absolutely right. And just to give more background for all of our participants and all of our viewers, basically the spending clause decision in the Landor case came down to whether or not the individual defendants, the prison officials, had agreed to be sued. So basically, the court is using a contract theory or the spending clause saying that federal government can attach conditions to spending and to giving money to state and local agencies. But you give it to the state and local agency like a prison system in Louisiana, but that does not mean that the individual employees of the agency or local agency have agreed to be sued in their capacity. And I think that's a misreading of the spending clause. In particular, as you said, Melissa, that our UPA came about to protect the most vulnerable of populations, being not only, of course, for land use, but also institutionalized persons, be they in prison or mental health facilities. And so it's a longer history of why they had to use the spending clause in the first place, see Bernie versus City of Flores. But basically here, the idea that individual defendants, employees of the state, have to opt into being sued is not found in legal precedents. There's no support for that. There's no reasoning for that. Furthermore, our UPA and Congress made it clear in our UPA that says that they have the right to enforce this law by appropriate relief, which means it allows for civil suits. So again, the idea that you have to have individual defendants or each employee of a state agency or local agency agree to be sued is not found in the previous understanding of the Constitution. And I want to say this has very broad ranging implications. As Justice Jackson notes, the court didn't limit its decision to just a interpretation of our UPA. It made the decision based on a constitutional interpretation of the spending clause, which now implicates all laws, all federal laws, where a spending clause is at issue. So we have environmental laws, health and safety laws. So now I think there's a real danger of if you're injured under these laws, are you actually able to seek appropriate relief as a claimant? And then further, last thing I want to say before Tom jumps in there, I do want to say that not only, as I mentioned in my own comments, the lack of even discussing the religious liberty violation is problematic, but also the fact that our UPA up until this point has been treated as a sister act to RFRA, the Religious Freedom Restoration Act. And they've been interpreted side by side. But now we have a split. And now you have a discordant, I think, understanding of these two sister acts, which also can prove problematic. Such that even in Tanzania versus Tanzan, the court allowed for damages against individual claimants for a RFRA violation, but now you can't get that for the most vulnerable populations in our UPA.
Thank you, Audra. And I forgot to mention before I turn to you, Tom, that in the Grand case, if anybody wants to unpack that a little more or hazard a prediction about how the court is going to grapple with that case, we welcome your thoughts on that as well. Over to you, Tom.
Yeah, Landor is a spending clause decision. It's a big deal for the spending clause. This is the court really going pretty much all in on this contract theory of the spending clause, that it's reducible essentially to a contract and between the state and the funding recipient, between the federal government and the funding recipient, and everything has to fit with contract principles. It ignores the fact that we're talking about a constitutional power here. It diminishes the necessary and proper clause that is also a source of power for Congress, and it could have a lot of effects on spending. I guess I want to disagree with Audra a bit about that the consequences of all of this are always, bad for minorities. I mean, we look at the actions of the Trump administration over recent years, and they have, of course, sort of vigorously tried to use federal funding to coerce conservative, MAGA policies. I have no doubt that if Landor had ruled for Mr. Landor and said, the spending clause can allow suits against officials who haven't consented, the Trump administration would be running with suits against individual officials at colleges and so on who receive federal funds and suing them for anything that they ever did in pro-diversity efforts and so on. So federalism, that does cut both ways. With that said, I think it's the wrong decision. As far as fixes are concerned, Congress, the court clearly said that Congress could step in here and do various things. It could require that, if a state prison wants to receive federal funds, it has to have its officials sign consent forms to being sued, or it would have to create a state cause of action against those officials, or consent to monetary damages against the state itself, which can't be given unless the state consents because of so-called sovereign immunity. Those are all possibilities. Of course, the question is whether you can get Congress to do this. just as it's a question whether you get Congress to do anything. I do think it's worth at least asking the question whether an administrative fix is possible. If the federal agency, which would be mostly the Justice Department, the Office of Justice Programs, that administers federal funding to state prisons, were to require consent itself, then that consent would be clear to the participants. Would it have to be done by Congress? There's definitely some lower cases and court cases and some indications in Supreme Court cases that no, Congress has to take that step. The agency can't. But as Audra said, it's pretty clear if you just look at RLUIPA that it authorizes this kind of damage. What the court said in Landor was that it's unconstitutional to do it without a consent form. So if the statute clearly authorizes it, then why can't the agency carry it out? I think it's at least worth asking the question because, as you say, who knows when Congress can act. The problem with this decision in practical terms is that by eliminating damages, it encourages state prisons to transfer prisoners to a new facility where they can't sue for an injunction because they haven't suffered the harm at the new facility yet. And they do this. They move prisoners around in order to escape forward-looking relief. So often damages are the only possibility.
Can I say something very briefly about this? Oh, can I jump
Stephanie,
in
go
really
ahead,
quick?
and then Audra.
Great. So really quickly, one other point that I want to make is, I think the biggest difference between Landor versus Tanzen, and Tanzen is a past case where the Supreme Court under RFRA, the Religious Freedom Restoration Act, as Audra mentioned, did allow damages against prisons when they had, did allow damages against government officials when they had done things to interfere with religious exercise. The biggest difference, and Tom alluded to this, is that RFRA was passed under Section 5 of the 14th Amendment, whereas our LUPA was passed under a different constitutional basis, the Spending Clause and the Commerce Clause power. So it's not the fact of a religious minority that drove the court's decision in these cases. Both cases had a religious minority. It was a Muslim plaintiff in Tanzania. I think that's overly simplistic. I agree with Tom. I share the policy concerns about the fact that we don't have damages here, but I just want to also flag that I think maybe one of the bigger problems here was the court's decision in City of Bernie saying that RFRA couldn't apply to state and local governments. I just think that was wrong. Under Section 5 of the 14th Amendment is an originalist matter. The best historical understanding of that. Michael McConnell has argued that. Tyler Lindley is arguing that. Brad Rapiero is arguing that. I've argued that in an article. So if the court hadn't got City of Bernie wrong, we wouldn't have this issue. Tanzan would have resolved this for state and local governments and the federal government. And so I just want to flag that that's an important piece of this puzzle as well.
Thanks, Stephanie. Audra?
Yeah, no, I think it's important, Stephanie's last point as well, that because they got City of Bernie wrong and struck city and state officials and government from RFRA, then Congress had to look at the spending clause in order to have the basis to create our UPA to protect this, at least, this vulnerable population as well as land use. So if they had gotten City of Bernie right, then we probably wouldn't be here. We'd be in a different place. But I did want to respond to what Tom said. I think it is a good point to remember that with federalism, what's good for the goose is good for the gander. So to your earlier point, Tom, regarding, if the court had come out for Mr. Landor, would the Trump administration then use that to go after higher education officials and so on and so forth? I think that's a real danger as well. So that's a good point and well taken. I definitely want to highlight something that Tom was mentioning regarding the contract theory for the Landor case. It's a grant. The spending clause is a grant that comes with strings. It's not a contract. And I have to make this clear because I am a recovered corporate attorney. I saw the light and ran to law and religion. But as a recovered corporate attorney, the court, again, gets contract and agency law wrong. If they're going to use agency law, then you have to do it right. And under agency law, the agent only has authority to act if it's given authority by the principal. And when it acts, if it does not have authority, then it's held personally responsible under torts and contract. So here, if the agent is the employee of the state or the local agency, and the principal is the state itself, assuming that they didn't have authority to abuse Mr. Landor this way, under agency law would say that they actually would be personally responsible for that. So again, the court needs to have corporate attorneys on the bench, but that's neither here nor there. But I do think that it's important for us to consider the court's reasoning in that case. Thanks,
Audra. Let's keep this conversation rolling and get into some other cases. There's been vigorous discussion already in part on the Mirabelli case. And I wonder what people think, and could, amplify this a bit more, what you think the case tells us about how the court will balance differing interests, that sometimes there's tension among these different interests, and including in the Mirabelli case, the privacy, autonomy, and liberty interests of minors versus the rights of parents to control the upbringing of their kids. And so that is one question. And then also just curious about any reactions that you would have to how these issues are balanced in the St. Mary's case as well, which obviously involves a government funding program as opposed to these programs that are involving people in school and teaching, which obviously some funds are involved there as well, but it's a different kind of setting. So there's two different settings, and how we balance, and again, some of you've already talked about this, how we balance the differing tensions that arise sometimes in these cases.
Well, one thing that I would push back on a little bit, Melissa, is the idea that what the court is doing with free exercise is balancing. I know some people characterize it that way. So what you're saying is perfectly intelligible and mainstream. I just don't think the court conceives of itself as balancing, like picking which of these things are more important. I don't think they're doing that in the Second Amendment context either. So what you see the court doing in the Second Amendment context is saying, is this a permissible reason to limit this type of defeasible right? Is this historically grounded sort of reason? And then if so, in Humani, the court was asking, is the government's action factually linked to that type of permissible reason? I think that's essentially what strict scrutiny is doing in the religious exercise context increasingly. So for sure, the types of permissible reasons that government could limit religious exercise at the founding, as demonstrated by a lot of the state constitutional provisions, were things like protecting public health or public safety, protecting property rights of others. Those were justifications that we're not balancing. It's just if government alleges that reason is permissible and then factually can demonstrate that its actions are really tightly linked to advancing that permissible reason, then the government wins. And then if the government doesn't point to a permissible reason, or if a close factual hook it can demonstrate on the record, then the government loses. And that is the type of question a court can answer. It's much more coherent, I think, than which of these do I think is more important. So how does that relate to the interests of youth? In Yoder, one way to think about that case is, so that was obviously the parental rights case that Mahmoud is citing, and then that Mirabelli is citing, dealing with Amish communities that didn't want to send their kids to public schools. And one of the arguments that was made is that government should be able to prepare young people to leave their families and their religious communities, that they no longer want to be part of that family and that community. The government needs to equip them to do that. And the court really gave that sort of argument the back of its hand. One way you might think of it is that's just not a historically permissible justification to limit religious exercise. That's not one of the reasons why government gets to limit religious exercise. And I think that's essentially what's going on in Mirabelli and Mahmoud. Like in Mahmoud, government doesn't get to justify interfering with religious exercise to try and disrupt the thinking of children about their views on traditional sexuality. And I have a forthcoming article in the Cornell Law Review where I talk about this a little bit, making laws for the human mind. So I think that's what's going on. It's just the court is asking, is this a permissible justification or not? Preparing youth to leave their families isn't a permissible justification. We actually have an unfortunate history where that's exactly what we did to Native American communities, where we prepared those young people to leave their families or sometimes forcibly removed them. And I think history has shown that that's a pretty significant thing to trust government with. Government will often get it wrong. I think there are important reasons why parental rights prevent government from being able to rely on that sort of justification, certainly in the religious context.
I wonder if I could just jump in on the Mirabelli case, because one of the things that's interesting to me about Mirabelli is that it's unclear whether the court is that concerned about parental control over the upbringing of children, whether it's assigning, great importance to that right in deciding the case, or whether the case is really predicated on how little weight the court assigns to the interests of a gender transitioning child, when the child's interests seem to be in conflict with the parents' interests. And after all, the California law in Mirabelli is only a problem for parents if their children don't want to discuss with them their gender transitioning. If they fully inform the parents of their use of pronouns, of their engaging in gender transitioning activity, then the California law really doesn't do very much to interfere with parental control. So I ask this hypothetical. Suppose we have children and the children are exploring faiths that are different than the faiths that their parents adhere to. And the children engage in activities in public school. They join religious clubs, they participate in group prayer during recess, they ask for religious accommodations, for religious garb, they take religious books out of the library. They do a lot of things that their parents would disapprove of because the parents want them to be faithful to their parents' beliefs. And the children are worried that there will be serious repercussions if the parents are aware of the child's exploration of different faiths. Not that the children will be abused, but parents have a lot of power to burden their children without reaching the legal threshold of abuse. So the children ask their teachers not to disclose their religious activities to their parents. Could state law allow or require the teachers to maintain the confidence of their children in order to protect the child's privacy, autonomy, and religious liberty interests? And I think this is a particularly important question if we're dealing with minors who are 15, 16, 17 years old, as opposed to children who are 6 or 7 years old. So how would this court resolve that issue? How much authority would they assign to parents to be able to learn their children's religious activities that are inconsistent with what the parents would like their children to believe? Or would we have some respect for the child's religious liberty and privacy and autonomy interests? It seems to me those are the hard questions that Mirabelli tees up, and I don't think it fully resolves that question, at least not in the court's opinion.
Thank you so much, Alan. Would anybody like to comment either on Alan's comments or Stephanie so far in this segment?
I was just thinking about this in general in terms of Mirabelli and in Mahmoud. As Stephanie mentioned, the core of those cases was the legal precedent's core was Yoder decision. And I know that maybe some participants aren't familiar with the Yoder decision, but the Yoder decision was from the 1970s, I believe. And it basically allowed for the Amish community to remove their children from the last 2 years, I think, of middle school and high school in order to receive a religious instruction on how to be Amish. And fast forward, that case is then used for Mahmoud for the opt-outs from objectionable material, and Mirabelli ostensibly under the idea of interfering with religious rights of parents with their children. I just wanted to note, I think it's interesting that the court used Yoder in that way when Yoder at the time was seen to be a very limited decision. It was limited for a small religious community. And the court also paid a lot of attention to the fact that the Amish were present in America from the founding and had a historical community, a historical religious community. So I just think it's interesting the way the court used a decision that was for a small population in a small community, and now has expanded it to this huge right for opting out of certain instruction.
Thank you so much,
Melissa,
Audra.
you asked
Tom.
about St. Mary in this
Yeah.
sort of issue of quote unquote balancing. Um, in Mirabella there, I mean, there is a just an unavoidable conflict between the interest of the transitioning child and the position of the parent. And, whatever the court decides about that, there's got that, unavoidable conflict. Um, it's a much more avoidable conflict in the case of St. Mary. First of all, again, around the state, there are 2,000 preschool providers. There's absolutely no sense that, LGBTQ families have any difficulty finding a provider because the Catholic schools in Denver are unavailable. Now, I do not actually believe that access to some provider is the sole element in deciding, whether the government's interest here involves a significant interest of public order that would qualify as a compelling interest. So I'm not saying that access to others is the sole answer, but it's a pretty significant part of the answer when you think when you recognize that excluding the Catholic schools from this program means that those parents will not get the subsidy. Many of them low-income parents will not get the subsidy that would enable them to send their children to preschool that everyone else gets. So we can have a situation in which both groups can live together and pursue their identities and live out their identities if we make that room for an exemption in this case. And then, as Stephanie emphasized, there's also kind of a false conflict because the state has already recognized that there are just a whole bunch of reasons to depart from formal, strict non-discrimination. Issues of discrimination are complex. They involve sometimes treating people exactly the same, but sometimes differential treatment in order to take account of differences, equity versus equality, whatever, formal versus substantive equality, whatever terms you want to use to describe that. The state has adopted substantive equality for lots of categories, and it needs also to adopt substantive equality for families in the Catholic schools of Denver. Not formal
I wonder if I
equality,
could
given the
respond to what
exception.
Tom said.
Thank you, Tom. Please, Alan.
It may be that in the St. Mary's case, there is very little cost to allowing the Catholic schools to exclude LGBTQ families. But it certainly should be clear that there will be numerous other circumstances where there will be real costs to excluded families. You may be a resident of a relatively small town, and the government subsidizes a variety of different social service programs, public health clinics, manpower training programs, soup kitchens, a variety of different kinds of social welfare activities. And to the extent that religious organizations are conduits for providing those services to intended beneficiaries, and the religious organizations as two things. One, will only provide those services to individuals who adhere to the tenets of our faith. And two, we will only hire people to work on those programs who adhere to the tenets of our faith. That can impose real costs to excluded families. Alternative services may not be easily available. There may be increased transportation costs or childcare expenses in order for the LGBTQ family to find the alternative provider, which is across town. It may be there isn't any alternative provider. Now, one of the things I've suggested is that if people are serious about trying to protect religious liberty while avoiding imposing serious costs on excluded groups, like members of the LGBT community, then what we should do is to recognize that religious liberty is a public good. And as a public good, when we protect it, we should spread the costs of doing so among the public at large and not allow them to fall on some small excluded minority who is being deprived of services or job opportunities that they should be entitled to. And so we would say that the government should accept responsibility for mitigating those costs by providing information that an excluded group might need to find an alternative provider, providing compensation for increased expenses, and even setting up an additional non-religious conduit to make sure that these services are available to everyone, as the law providing for the support of these services intended. So I wonder how Tom and other panelists would feel about the recognition on the part of government, and if we're going to accommodate religion by allowing religious institutions that operate as conduits to exclude people, whether because they're members of the LGBT community or they have their adherence of the wrong faith or whatever, whether the government has some responsibility to spread and mitigate those costs. And that would be a way to limit the intrinsic conflict in some of these cases.
Can I follow up or respond to that?
Sure, sure.
Yeah. So, I mean, I agree with you in principle about that, Alan. The standard from the Supreme Court's voucher case from almost 25 years ago from Cleveland says that a voucher program is permissible if there are genuine secular alternatives to the religious providers. And I think genuine secular alternatives, as that phrase suggests, should have some meaning. If we care about religious choice, then there should be secular alternatives that are not, ridiculously costly, or alternatives for the groups that can't go to the religious schools. And so all of the things that you suggest, I think, are possible ways of doing that, whether that's public provision of the service directly or some of these other mitigating things. I would not want to take that principle so far as to make it sort of really hard to include religious providers in a program. Because there's always some cost, and there's always some, the other providers might not be as good as the religious provider, so there's always some cost to others of not being able to go to a religious provider that excludes them. Because if you don't allow religious providers, that excludes the people who want, need, and for powerful reasons want to use those providers. You can't just say, well, if we don't have religious providers, the religious people can go to the secular ones. Everybody can go to the secular ones with no cost. So I do think that genuine alternatives is a good direction, and I think the things that you suggest make a lot of sense. But I just would not want to make that so onerous that it leads us to going back to saying discrimination against religious providers.
Thank you.
Before we move to St. Mary's, can I say something about this, Melissa?
Yes, and then we'll turn to a last segment of the QA.
Okay, great. But just very briefly, I wanted to point out that there's an amicus brief my friend Mark Storsey and I filed that looked at some of the historical evidence at the founding about government provision of funding to religious groups alongside other groups. And so one of the things that's really important, I think, to keep in mind is that funding was controversial at the founding when it basically embodied a coerced tithe, when government was saying, you must pay this earmarked piece of money to this religious group, such that it's essentially coercing a religious exercise. Tithing is a form of religious exercise. And sometimes it was the church tax was even called a tithe by people like Alexander Hamilton and other founding era figures as different. It was different at the founding of funding that was provided in a more even-handed way, some publicly available benefit. Virginia, Maryland, North Carolina, South Carolina, Georgia, some of the middle states, and the federal government all funded religious groups alongside other groups when they're providing public benefits. And in two different contexts where the government went to take away funding to religious groups, in Sharif Israel and the Ursuline nuns, they objected and pointed to religious exercise constitutional sort of concerns as a basis why it would be problematic to take that sort of funding away. And so I think that's a reason here as well to think about if the reason government is removing funding is because this group wants to perform their religious exercise of building their religious community, the same way that the LGBTQ school wants to build their community, and they can't do it for religious reasons. Founding era evidence, I think, suggests that government is going to have a hard time having a constitutional justification for that lack of even-handedness when it comes to the religious groups.
Thanks, Stephanie. We certainly will have enjoy more discussion on those topics that I'm not sure we'll be able to fully exhaust today. In fact, I am sure we wouldn't be able to fully exhaust them. But let me turn in our last segment back to some other issues, including the Ten Commandments cases. Do you all think cert should be granted by the court in one or more of these cases? How do you think the court should approach them? There are arguments that have been made from history to support these laws. What about arguments from history that might be made by challengers, for example, the Fifth Circuit decision? Tom has kind of gotten into this a little bit, but we might want to talk about it further. And also, one in the Fifth Circuit case, one argument of the majority was that denominational preference, the prohibition on government preferring some denominations over others, doesn't apply to government speech or religious symbolism. And if it did, then it would just scour the public square of any religion at all. And so wondered if any of you wanted to react to those cases and that, the Supreme Court, the prospect of the Supreme Court taking up these issues.
I'd certainly like to talk about it, if you don't think I've spoken too much on the panel already.
Go ahead, Alan.
I do come from New York, and we tend to talk a lot. So I think the Fifth Circuit's argument that concerns about religious equality and anti-preferentialism have no application to the government's use of religious language or symbolism is simply wrong. And I would hope that the Supreme Court, if it grants cert in this case, resoundingly rejects that analysis. The Fifth Circuit seems to take the position that religious equality is an all or nothing proposition. Either everything that references religion has to be excluded from the public sphere, or we have to allow government to express any religious message that it wants to, free from constitutional constraint. And I think that's not true for religious equality any more than I think it was true for religious liberty. I think this is the mistake that Scalia made in Smith, whereas you'll recall from Scalia's perspective, it was very much an all or nothing proposition. If we took free exercise rights seriously, they would trump everything. We would have anarchy. If we didn't take free exercise rights seriously, the alternative was rational basis review, which is what Smith gave us for neutral laws of general applicability, and there'd be no free exercise protection at all. And I think, that argument is clearly in error, and a cursory look at free speech doctrine demonstrates why it's in error. Because if we're talking about free speech, which is certainly a fundamental right, no one suggests that we ask simplistically, does this law abridge freedom of speech? And if it does, it gets strict scrutiny review. And if it doesn't, it's reviewed under rational basis review. Instead, we have a very sophisticated, nuanced, complex framework that the court has developed that determines what are the appropriate standards of review to apply in different contexts. And I'd just like to read a very, very short statement from Justice Barrett from her concurrence in the Fulton case, which really emphasizes this point. In discussing whether we should overrule Smith, Justice Barrett said, "If what Smith,
Alan, your audio is fading in and out, and we can't really hear you
I'm
anymore.
sorry. Is it better now when I'm facing you?
Yeah, when you're facing the camera, it's good.
Okay.
And am I right that we only have 3 minutes left of the webinar, Melissa?
I'm not going to read the statement then. Okay. But just let me say that equality, like liberty, is subject to a wide range of interpretations and applications. It's certainly true if we're thinking about equal protection doctrine. We don't apply the same standard of review to all laws that are challenged as violating the Equal Protection Clause. We have different standards of review. We distinguish between facially discriminatory laws and laws that impose disparate impact. Cultural concerns influence the way we think about religion. It's unconstitutional to have racially segregated bathrooms. It's not unconstitutional to have gender segregated bathrooms. You could have a lot of nuanced, sophisticated doctrine that would determine when it's permissible for government to use religious messages or religious symbolism and when it isn't. And just as one obvious situation where it's clearly permissible for government to use religious symbols is if we look at national cemeteries where our fallen soldiers are buried. The Department of Veterans Affairs provides belief emblems that the government pays for on the headstones of every fallen soldier who's buried in those cemeteries. Right now, we have, I think, around 85 different belief emblems that are accepted. And I don't know anyone who thinks that's unconstitutional. So you can certainly have religious speech and religious symbols where those messages are expressing our commitment to religious pluralism and recognizing that all faiths are entitled to equal respect under our constitutional system.
Could we do like
Thank
30
you, Alan.
seconds
Yeah,
from a
that's
couple of us on
yes, totally. Tom or Stephanie, Stephanie, Audra.
I had mentioned I had thoughts about this too. So
Yeah, Steph, you want to go first?
Yeah, go ahead, Stephanie.
Sure. Just very briefly, why I think the Supreme Court shouldn't grant cert in this case is there have been 3 circuits that have addressed the Establishment Clause since Kennedy, the Fourth Circuit, the Third Circuit with Judge Hardiman, and now the Fifth Circuit en banc. All of them have taken the same approach. The historical hallmarks of the establishment is at a pretty low level of generality. So there's no circuit split. And in fact, all of the scholars, like including I hear Tom talking about this, don't disagree about those hallmarks being wrong. It's just sort of like, at what level of generality should we implement them as a modern doctrine? So that's error correction, not even about the history, but about like methodology of what level of generality we ought to implement it. If we implemented it at a much higher level of generality, there's a lot of founding era examples that no longer survive. The first Congress had legislators before chaplains who prayed. You could argue that that's coerced religious instruction. Madison's Thanksgiving Proclamation. I mean, then a lot of modern casualties multiplied. The Pledge of Allegiance, one nation under God, cited before captive audiences, including Jehovah's Witnesses who object to that and view the flag as idolatry. Like that doesn't survive this sort of test. So that among other reasons is another reason why I think it ought to be interpreted at a lower level of generality. And finally, what counts as coercion in the religious exercise context ought to count as coercion too for establishment. In Mahmoud, the parents and the children weren't asking to take all the books out of the classroom. They weren't asking to take the books off of the shelves that had to do with LGBTQ things. They were asking for them not to be read aloud to the children. That was the objective interference. There is no reading aloud of the 10 Commandments here. There is no coercion to do anything. There's no peer pressure to do anything with respect to the 10 Commandments. Unless we think that under religious exercise claims like Mahmoud, parents should be able to take down all of the LGBTQ posters on the walls. And I don't think that would be a winning free exercise claim. I don't think there's a winning Establishment Clause claim here either.
Thanks, Stephanie. Tom, you want to go next?
So the children are coerced to be in school the way people were coerced to be in a church under historic establishments. And if you've got religious instruction chosen by the state in that situation, you've got a hallmark of an establishment. An establishment, anything outside the public schools is not really a good analogy unless people are coerced in some way to be in that situation by law, the way the court recognizes that children are coerced to be in public schools. And under God is a hard one. Is that a case of ceremonial deism that the court has recognized? Is it fundamentally, we might have to make decisions about fundamentally what is a patriotic document with a religious reference in it, as opposed to something that leads off with 5 commandments, like you shall have no other gods before me, and don't make graven images, and so on. Whatever you do, there's going to be some line about when a religious reference in some document is not sort of religious instruction. But I think that the syllogism is pretty clear here. Coerced religious instruction was part of the historic establishment, and coercion to be in the place in school and read the 10 Commandments as religious instruction every day is an example of that.
Thank you, Tom. Audra?
Yeah, I just want to, I do agree with Tom. I just want to add that I think it'd be interesting if the court does take up Nathan versus Alamo Heights, particularly because of the question of whether or not Stone v. Graham was overruled because it relied on the Lemon test, which is a bigger question of whether or not, because the Lemon test has been overturned, does that now mean all cases are now overturned, up for debate, up for question? So I think that'd be interesting for the court to take up and answer that opinion, give that opinion. I think it's also beyond the Establishment Clause issue, the Free Exercise Clause issue, because I do agree that it is coercion. If we force children to be in school, we force them to be in classrooms with posters, and the posters are government speaking. The posters say, raise your hand before speaking, raise your hand before going to the bathroom, learn your ABCs, because the ABCs are important, right? So the government is speaking in this way. So I think of it as a free exercise violation for the children and their parents, other children who have to be in classrooms where the 10 Commandments and a particular version of the 10 Commandments are there. And then the question is, can a parent use a Mahmoud opt-out to remove the children from classrooms that have 10 Commandments posted, right? Like, how far do we go with that? And also just to keep our eyes on Texas, because not just the 10 Commandments that they want to put up, they also have the Bluebonnet curriculum, which is a K-5 curriculum for public schools. It allows, if schools opt to get the money from the state, then they have to use Christian-based, and it's mostly religious, but Christian-based doctrine inside the curriculum for K-5 schools. So it's not just limited to 10 Commandments. There's a bigger picture going on here in Texas and the project. And then lastly, the question and this contention about the method of generality when using the hallmarks, right? Which goes back to using the historical practices and understandings test that the court has said we have to use. I do think there is disagreement among scholars when it comes to even the hallmarks themselves. The hallmarks are based on a work by scholar Michael McConnell, and it was picked up by Justice Gorsuch, I believe, in Shurtleff in a concurrence, and then it's been carried on through to Kennedy. What's interesting is that even in McConnell's work himself, he just gave the hallmarks as a way, as a big picture to look at several decades of establishment before Civil War. But it's only a way to think of generalize these categories, right? It's not supposed to be a measuring stick going forward on whether or not something is establishment. So I think there is debate amongst scholars and even practitioners on what the hallmarks are if you are going to use a history test.
Thank you so much. And pardon me, Alan, did you have something quick to get in? I just
I was going to say is I'm concerned that we're limiting this discussion to schools, because I think there's a deeper question of what limits there are on the majority using government resources and the government voice to blanket public life with their sectarian beliefs, not just public schools. Are there any constitutional constraints on the government's use of religious messages and displays to proselytize, to promote the majority's beliefs?
Thank you, Alan. And thank you to all of our panelists. We're at time, so unfortunately we have to leave it here for today. And I know that's tough because we've discussed a lot of issues, but there's a lot of discussion that would really be profitable to be had in the future. And we got to many questions, but not all of them. And thank you again to attendees for your really terrific questions. The good news is that we are fully committed to airing these issues out moving forward with more events and more discussions. So I just want to say a big word of thanks to our panelists for taking the time and for bringing such insight to these issues and for having such a great discussion that we could profit from. I also want to thank Wake Forest, Dean Corey Walker, all the people who made this happen, including Dan Culpepper and Catherine Morris. And I, again, want to thank all of you. It is so important at this time in our nation's history to have these discussions, including about this fundamental right of religious freedom. And I just really appreciate everybody's engagement across differences in views and perspectives. So we will look forward to doing more in this space. We thank everybody for their time and their investment and their efforts. And we just look forward to seeing you next time. So thanks everyone from Wake Forest University Divinity School, and we'll look forward to seeing you the next time.